So, Republicans are threatening to imprison former President Bill Clinton and former Secretary of State Hillary Clinton for not answering questions about Jeffrey Epstein, the same Jeffrey Epstein whose files the Trump Justice Department has been dragging its feet on releasing for months, the same Jeffrey Epstein that Donald Trump himself was photographed with dozens of times, the same Jeffrey Epstein whose subpoena Trump defied in 2022 with zero consequences, and they're doing it with a straight face, on camera, while the DOJ has literally released less than 1% of the files it was legally required to hand over. But sure, the Clintons are the obstruction problem here. What you're about to watch is James Comer, the chairman of the House Oversight Committee, testifying before the House Rules Committee to push for criminal contempt of Congress charges against both Bill and Hillary Clinton, charges that could, under federal law, carry up to a year in prison. And the reason this matters is not just what he says, but what he refuses to acknowledge about everyone else in this investigation who has gotten the exact opposite treatment. Take a look at this political theater, and I will definitely give you my take later at the end.
I welcome your testimony.
Thank you, Chairwoman Fox and Ranking Member McGovern. I urge the Rules Committee to grant a prompt rule for the House's consideration of both the resolution recommending that the House of Representatives find former President of the United States, William J. Clinton, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform, and the resolution recommending that the House of Representatives find former Secretary of State Hillary R. Clinton in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. Subpoenas are not mere suggestions. They carry the force of law and require compliance. Former President Clinton and former Secretary Clinton were legally required to appear for a deposition before the House Oversight Committee. They refused, and actions have consequences. Last July, Republicans and Democrats on the House Oversight Committee's Federal Law Enforcement Subcommittee unanimously approved a voice vote, a motion to subpoena former President Clinton and former Secretary Clinton for depositions as part of our investigation into the federal government's handling of the Jeffrey Epstein and Ghislaine Maxwell criminal cases. On August 5th, I issued subpoenas to them. The testimonies of President Clinton and Secretary Clinton are critical to understanding Jeffrey Epstein's sex trafficking network and the ways he sought to curry favor and influence to shield himself from scrutiny. In fact, then Secretary of State Clinton would have signed off on the annual Trafficking in Persons report. In 2010, under Secretary Clinton's tenure, that report began covering trafficking within the United States. Given her service as Secretary of State, she could provide firsthand information about the federal government's efforts to combat international sex trafficking. Their testimony may also inform how Congress can strengthen laws to better combat human trafficking. Since issuing the subpoenas, the Oversight Committee has acted in good faith. We've offered flexibility on scheduling. We've tried to accommodate. The response we received was not cooperation, but defiance, repeated delays, excuses, and obstruction. President Clinton and Secretary Clinton claimed to have been treated unfairly because the Oversight Committee accepted written statements under penalty of law from former U.S. attorneys Gonzalez, Holder, Lynch, Sessions, and Garland, as well as former FBI Director Comey. Those written statements were accepted because none of those officials recalled any information relevant to the Epstein investigation, nor could we find any evidence that they did have personal relationships with Epstein. By contrast, the Oversight Committee required in-person testimony from former U.S. Attorney General Barr and former U.S. Secretary of Labor and U.S. Attorney Acosta, both Republicans, because they possessed information directly relevant to the investigation. The Clintons had documented relationships with Epstein and Maxwell, including President Clinton's trips with Epstein and Maxwell, evidenced by numerous photographs, flight log records, wedding invitations, and other materials. We repeatedly informed the Clintons' attorneys that a written statement would not be sufficient. The subpoenas required a deposition. Federal courts have consistently held that witnesses may not impose their own conditions upon the manner of congressional inquiry. Yet President Clinton and Secretary Clinton attempted to do exactly that. submitting a brief, bulleted written statement that was neither comprehensive nor responsive to the Oversight Committee's many unanswered questions. No person, not a former president or a private citizen, may willfully defy a duly issued congressional subpoena without consequence. And there can be no doubt that this bipartisan congressional subpoena was lawful and duly issued, as Ranking Member Garcia confirmed for the record during the committee's markup. The Clintons have flatly refused to appear at all, despite repeated warnings that the Oversight Committee would move forward with contempt proceedings. 2 weeks ago, the Oversight Committee voted on a bipartisan basis to hold both President Clinton and Secretary Clinton in contempt of Congress for refusing to comply with their subpoenas. President Clinton must be held accountable for his actions. Secretary Clinton must be held accountable for her actions. The Rules Committee and the full House must take this opportunity to uphold Congress's investigative authority. And we must do so to demonstrate to the American people that justice is applied equally to everyone, regardless of position, pedigree, or prestige. I also urge the Rules Committee to grant prompt rule for Representative Gill's House Joint Resolution 142, disapproving the action of the District of Columbia Council and approving the D.C. Income and Franchise Tax Conformity and Revision Temporary Amendment Act of 2025. As I've said many times before this committee, Congress has the constitutional right to review legislation passed by the D.C. Council under the D.C. Home Rule Act. It also has authority to block such legislation. In this case, it should do just that. In December this past year, the D.C. Council enacted, without the mayor's support, legislation that blocks corresponding tax relief for D.C. residents and businesses that is afforded them at the federal level by the Working Families Tax Cut Act. These reforms provide much-needed tax relief for both individuals and businesses, relief that keeps more of Americans' money where it belongs, in their pockets. However, the D.C. Council has cherry-picked pieces of these federal tax reforms and decided to just ignore the application in the local tax code. The tax provisions they have chosen not to implement in the D.C. tax code include no tax on tips, no tax on overtime, no tax on Social Security for senior citizens, no tax on auto loan interest. This hurts seniors and hardworking American families, and that's just the start of it. They've also cut various tax credits for D.C. local businesses, including research and development and manufacturing incentives, stifling them from growing their local economy. The House must swiftly exercise its constitutional responsibility to oversee the District of Columbia and stop this misguided legislation from going into effect. I urge my colleagues on both sides of the aisle to unite in the support of D.C. taxpayers and businesses and support this necessary resolution of disapproval. Again, I ask the Rules Committee to grant a prompt rule for the House's consideration of these measures, and I welcome the committee's questions. I yield back, Madam Chair.
Thank you, Mr. Comer. Mr. Walkinshaw, can you hold on just 1 second?
Sure.
I can't figure out where that pounding noise is coming from. No. I'm sure it's distracting to me. I don't want it to be distracting to you all. We thought it might be coming from your mics. That's why I wanted.
Okay. So if that made you uncomfortable, good. Trust that feeling, because it should make you uncomfortable, and here's exactly why. Because there are things he just said on camera that he is absolutely banking on you not knowing. First, and this is the one that should make your jaw drop, Comer just stood up there and talked about how no person may willfully defy a duly issued congressional subpoena without consequence. Beautiful, inspiring, very serious stuff. Here's what he did not mention. In 2022, Donald Trump, who was at that time a former president, exactly the same way Bill Clinton is a former president right now, was subpoenaed by the January 6th Select Committee to testify. Trump's lawyers fought it, they stalled, they sued the committee, and then the committee just withdrew the subpoena. No contempt vote, no criminal referral, nothing. The committee withdrew that subpoena in late December 2022, and Trump never testified. Shocking, I know. Absolutely shocking that the rules worked differently when it was Donald Trump. Now here's the part where it gets even more interesting. Because Comer did not just forget to mention this, he actively contradicted it in the same hearing. He said that the committee would not attempt to compel testimony from the current president, meaning Donald Trump, about Epstein, because it could not force a sitting president to testify. Okay, So sitting presidents are off limits. Got it. But former presidents? Those are fair game. Except, and pay very close attention here, the only former president who has ever actually been threatened with criminal contempt in this story is a Democrat. The sitting president, who also has a well-documented relationship with Epstein photographs, flight logs, the whole catalog, is simply not part of the equation. I'm sure that's just a coincidence. I'm sure. Here's where the actual double standard lives, though, and this is the part Comer really does not want you to think about. According to the House Oversight Committee's own records, 10 people were subpoenaed on August 5th, 2025. Former Attorneys General Gonzalez, Holder, Lynch, Sessions, Barr, and Garland, former FBI Directors Mueller and Comey, and both Clintons. Comer himself acknowledged that 5 of those people, Gonzalez, Holder, Lynch, Sessions, and Garland, were allowed to submit written statements instead of appearing in person. Mueller and Comey were also given written statement options. The only people required to sit for in-person depositions were Barr, who is a Republican, and the Clintons. Now, Comer's explanation for why Barr had to appear in person is that Barr, as former Attorney General during the time Epstein was actually being prosecuted, had directly relevant information. That tracks. But here's what Democrats on the committee have been pointing out, and what Comer has been conspicuously ignoring. The Justice Department under Attorney General Pam Bondi, a Trump appointee, was also subpoenaed for its Epstein files back in August, and the DOJ has produced only a fraction of the documents it was legally required to hand over. Representative Robert Garcia, the ranking Democrat on the Oversight Committee, has raised this point directly. Where is the pressure to get Pam Bondi to release the files? No contempt. Vote for her. No criminal referral, not even a strongly worded letter that anybody actually followed up on. And the timeline on the DOJ's compliance is, I genuinely don't have a more precise way to say this embarrassing. The Epstein Files Transparency Act was signed into law by Donald Trump himself on November 19th, 2025. The law gave the Attorney General 30 days to release the documents. By December 19th, the actual legal deadline, the DOJ released a heavily redacted initial batch that drew bipartisan criticism. According to a court filing by the DOJ itself, filed in early January 2026, only about 12,000 documents had been released, totaling roughly 125,000 pages, out of more than 2 million documents still under review. That is less than 1%. Representative Thomas Massie, a Republican, described what the DOJ had given Congress as the sleeves off their vest. The final massive release didn't come until January 30th. Over 6 weeks past the legal deadline, and even that release was plagued with errors so bad that attorneys representing more than 200 Epstein survivors asked federal judges to order the entire website taken down. But the Clintons are the obstruction problem, sure. So here's what you can take away from this. In plain language, the next time someone tells you this is just about holding powerful people accountable. James Comer is pursuing criminal contempt against the Clintons, a process that could result in their imprisonment, while the Trump Justice Department has violated the same congressional mandate to produce documents, and nobody in that hearing room is threatening Pam Bondi with a single day in jail. So here's what this actually means, not in the abstract, but for you watching this right now. If you are someone who genuinely cares about Jeffrey Epstein's victims, and the overwhelming majority of Americans across both parties do, then what is happening right now is that the congressional investigation that is supposed to be delivering answers to those victims is being used, at least in part, as a political weapon aimed at one family, while the actual federal documents that would answer the most important questions are trickling out months late, with botched redactions that have re-traumatized survivors. That's not accountability. That's theater dressed up as accountability. Polling from December 2025 showed 74% of Republicans and 91% of Democrats supported the full release of the Epstein files. That is not a partisan issue. That is a national issue. And yet, the people who are supposed to be delivering those answers are spending their energy on contempt proceedings against the Clintons, while the DOJ sits on documents. What this means for the integrity of Congress as an institution is genuinely serious. Criminal contempt of Congress is one of the most severe tools lawmakers have. It has been used only a handful of times in modern history. Steve Bannon and Peter Navarro both served 4-month prison sentences for it, both for defying January 6 subpoenas. The fact that it is now being wielded against the Clintons while a sitting attorney general who has violated a congressional mandate faces no equivalent pressure sets a precedent that contempt is a tool for political targeting, not institutional enforcement. And that precedent does not go away once it's been set. So what is this actually for? Comer will tell you it's about justice. It's about equal application of the law. It's about the victims. And sure, on its face, holding someone accountable for defying a subpoena is legitimate. But here's what the evidence actually suggests. The Clintons agreed, on the evening of February 2nd, to sit for depositions. They accepted every single term Comer had laid out. And Comer's response was not, "Great, let's schedule it." His response was that the terms lacked clarity, yet again, and that they had provided no dates for their depositions. The ranking Democrat on the committee, Robert Garcia, said the Clintons had accepted every single term that James Comer has asked for. So the question becomes, if the goal was actually testimony, and they just said, yes, what exactly is the problem? Bill Clinton's deputy chief of staff, Angel Urania, responded to Comer's continued pushback even after the Clintons agreed to testify by posting on X. They negotiated in good faith. You did not. But the former president and former secretary of state will be there and look forward to setting a precedent that applies to everyone. That is a pretty direct statement, and the fact that it came out on the same night the Clintons agreed to every condition Comer had set makes it very difficult to dismiss. On the other side of this, Representative Thomas Massie, a Republican, by the way, has been one of the most vocal critics of the DOJ's handling of the Epstein files. Massie described what the administration had given Congress as the sleeves off their vest. And CNN ran an analysis piece on the Trump administration's handling of the Epstein files with the headline, "The Trump administration's elaborate mirage of transparency on Epstein," which is a headline written by CNN, not by me, CNN. Here is where things stand as of right now. The Clintons have agreed to testify. Comer has not confirmed whether he will accept. The House was expected to vote on the contempt resolutions this week, but the Rules Committee postponed advancing them after the Clintons agreed to Comer's terms. The DOJ released its final batch of Epstein files on January 30th, over 6 weeks late, and has since claimed it has fully complied with the law. That claim has been rejected by multiple members of Congress, from both parties. This is not about whether the Clintons should testify. Frankly, at this point, most people think they should, and they just said they will. This is about whether the rules of this country actually apply equally, or whether accountability is a word that only gets pointed in one direction. And the answer, based on everything we just watched and everything we just laid out, is that it does not. Not right now. Not in this Congress. And here's the thing that should stick with you after you close this video. The people who are supposed to be getting answers, Epstein's victims, the survivors whose names were botched in a federal document released just days ago, they are not the ones being centered in this fight. The fight is between James Comer and the Clintons. And while that fight is happening, the Justice Department is still sitting on documents, the survivors are still waiting, and the one person in this entire saga who has never once been threatened with a single day in prison for defying a congressional subpoena is still in the White House. Before you go, if you want more breakdowns like this that cut through the noise and focus on the facts, make sure you're subscribed to the channel. Click the notification bell so you don't miss the next video when it drops. Share this with someone who needs the full context, not just the headlines. And stick around, there's a lot more coming. Thanks for watching. Bye.